Your perfect oral contract might be worthless in court. The statute of frauds is a defense making certain oral contracts unenforceable. It does not render the contract void, only unenforceable. The statute of frauds applies exclusively to executory contracts. Executory means the contract has not yet been fully performed by both parties. If a contract falls within the statute of frauds, a writing is mandatory. This writing must be signed by the party against whom enforcement is sought. Failure to satisfy the statute of frauds prevents judicial enforcement. The contract's existence is irrelevant without the required writing. The primary purpose of the statute of frauds is evidentiary. It prevents fraudulent claims regarding contract formation. 6 categories of contracts are subject to the statute of frauds. Use the mnemonic MYLEGS to remember them. MYLEGS stands for marriage, year, land, executor, goods, and suretyship. The marriage provision covers promises made in consideration of marriage. This includes prenuptial agreements and promises to convey property. It does not apply to simple mutual promises to marry. The 1-year rule applies only if performance is impossible within 1 year. The 1-year period starts from the date the contract is formed. If performance is merely highly unlikely within 1 year, the contract is outside the statute of frauds. Possibility of performance is the only test. Contracts for a lifetime are outside the statute of frauds. The person could die within 1 year, completing the performance obligation. Contracts with an indefinite duration are also outside the statute of frauds. Contracts terminable at will by either party are not subject to the 1-year rule. Full performance by one party often removes the contract from the 1-year rule. The land provision covers contracts for the sale of any interest in real property. This includes the sale of land itself. It also covers mortgages, easements, and restrictive covenants. Leases exceeding 1 year must also satisfy the statute of frauds. A lease for exactly 1 year or less is generally excluded. The transfer of fixtures is typically covered by the land provision. Fixtures are items permanently attached to the real property. Contracts between a broker and a client for land sale services are usually excluded. State statutes may sometimes require a writing for broker agreements. The land provision applies to the transfer of the interest, not services related to the transfer. The executor provision applies to promises by an executor to pay estate debts personally. This promise must be written to be enforceable against the executor's personal assets. The suretyship provision covers collateral promises. This is a promise to answer for the debt or duty of another person. The promise must be secondary to the primary debtor's liability. The primary debtor must remain liable to the creditor. A promise to pay one's own debt is never a suretyship promise. The main purpose rule is a critical exception. If the surety's primary purpose is to secure a personal economic benefit, the promise is outside the statute of frauds. This is also called the leading object rule. Such a promise is enforceable even if made orally. The goods provision is governed by Uniform Commercial Code Section 221. It applies to contracts for the sale of goods priced at $500 or more. The required writing under the Uniform Commercial Code is less formal than common law requirements. The writing merely indicates that a contract for sale was made. It must also specify the quantity of goods involved. The contract is enforceable only up to the quantity shown in the writing. The writing must be signed by the party against whom enforcement is sought. The merchant's confirmatory memo exception is important. If both parties are merchants, one merchant's signed confirmation binds the recipient. The recipient must fail to object to the confirmation within 10 days of receipt. The Uniform Commercial Code provides 3 major exceptions to the writing requirement for goods over $500. First, contracts for specially manufactured goods are enforceable. This applies if the seller has made a substantial beginning of manufacture. It also applies if the seller has made commitments for procurement. Second, the contract is enforceable if the party to be charged admits its existence. This admission must occur in court, pleading, or testimony. Enforcement is limited strictly to the quantity admitted. Third, the contract is enforceable regarding goods that have been accepted. It is also enforceable for goods for which payment has been made and accepted. This exception applies only to the portion of the contract actually performed. Under common law, a sufficient writing must identify all contracting parties. It must also recite the essential terms of the agreement, and crucially, it must be signed by the party against whom enforcement is sought. This party is known as the party to be charged. The writing does not need to be a single formal contract document. Multiple documents can be pieced together to satisfy the requirement. These documents must clearly relate to the same transaction. The Uniform Commercial Code requires only a writing indicating a contract for sale. It must specify the quantity and be signed by the party to be charged. Missing terms, except quantity, can often be supplied by uniform commercial gap fillers. The quantity term is absolutely essential under the Uniform Commercial Code.
The doctrine of part performance is a major equitable exception. It applies primarily to oral land sale contracts. Part performance allows enforcement if the buyer takes possession of the land. The buyer must also pay part of the purchase price or make substantial improvements. The buyer's actions must unequivocally refer to the contract's existence. Promissory estoppel is a modern Reliance exception. It allows enforcement of an oral contract otherwise barred by the Statute of Frauds. The promisee must have reasonably and detrimentally relied on the promise. Enforcement is required only if injustice can be avoided no other way. This exception is applied cautiously and varies significantly by jurisdiction.